The right to remain silent. The Fifth Amendment protects you from self-incrimination during any police encounter, including traffic stops. When an officer approaches your window, you must provide your driver's license, vehicle registration, and proof of insurance. Beyond these documents, you have no obligation to answer questions about where you're going, where you've been, or whether you've been drinking. Officers frequently ask questions designed to elicit incriminating responses. Do you know why I pulled you over? Invites you to admit to a violation the officer may not have observed. Have you had anything to drink tonight? Creates probable cause for a DUI investigation even if you answer just 2 beers. You can politely decline by saying, I'm exercising my right to remain silent. Your silence cannot be used as evidence of guilt or provide probable cause for search or arrest. Anything you say is admissible evidence, even casual statements made before Miranda warnings. Miranda only applies once you're arrested and being questioned. During routine stops, you're detained but not arrested, so officers can question you without reading your rights. This makes Fifth Amendment protection critical. However, remaining silent doesn't mean being hostile or refusing lawful orders. You must comply with document production and commands to exit the vehicle. The distinction is between required compliance and voluntary cooperation. Cooperate with lawful orders, but understand you have no obligation to participate in fishing expeditions disguised as conversation. The right to refuse consent to search. The Fourth Amendment protects you from unreasonable searches, meaning police cannot search your vehicle without consent, a warrant, or probable cause. When an officer asks, "Do you mind if I search your car?" they're requesting consent because they lack legal justification to search without it. If they had grounds to search, they wouldn't ask permission. You have the absolute right to refuse by clearly stating, I do not consent to a search. Refusing consent cannot be used as probable cause. The Supreme Court established in Ohio v. Robinette that officers don't have to inform you that you can refuse, which is why many drivers mistakenly believe they must comply. Once you refuse, officers may still search if they develop independent probable cause, such as observing contraband in plain view, smelling marijuana, or using a drug detection dog. However, the search must be justified by factors independent of your refusal. Some officers will claim they can search anyway, or that refusing makes you look guilty. These statements don't change your rights. You cannot physically resist a search, even an illegal one, but you can clearly state your refusal and preserve your Fourth Amendment claim for court. Consent eliminates Fourth Amendment protection entirely. Without consent, the burden is on the state to prove the search was legal. The right to know why you were stopped. Under Terry v. Ohio, police must have reasonable, articulable suspicion to initiate a traffic stop, meaning specific facts that justify the detention. You have the right to know what those facts are. Officers must have observed a traffic violation, equipment violation, or behavior suggesting criminal activity. You can ask, "Officer, why did you pull me over?" This question forces the officer to articulate their justification on your recording and prevents the stop from expanding into unrelated investigations. It also establishes a record if the stop was pretextual. Pretextual stops are legal under Warren v. United States, but patterns can support claims of discriminatory enforcement. Don't interrupt the officer's initial approach or refuse documents while demanding an explanation. Comply with document requests first, then ask for the reason. The reason given at the scene must match the citation or police report. Discrepancies can be used to challenge the stop's legality in court. You cannot refuse to cooperate because you disagree with the stated reason, but you can document the interaction and challenge it later through proper legal channels. The right to record the interaction. The First Amendment protects your right to record police officers performing their duties in public, and every federal circuit court has affirmed this right. You can record using your phone, dashboard camera, or any device. You don't need the officer's permission. The recording should be visible and positioned where it doesn't interfere with officer safety. Holding a phone at chest or dashboard level works. 12 states have two-party consent laws for audio recordings, but courts have held these don't apply to on-duty police in public because they have no reasonable expectation of privacy. Officers cannot order you to stop recording, cannot seize your phone without a warrant, and cannot delete your footage. If an officer demands you stop recording, you can respond, "I'm exercising my First Amendment right to record this interaction." If they take your phone, state clearly, "I do not consent to any searches of this device." Recordings provide the most reliable evidence of what occurred. Without a recording, disputes become your word against theirs. Recordings have exposed illegal searches, planted evidence, and excessive force. The right to record doesn't exempt you from lawful orders. If ordered out of the vehicle for safety reasons, you must comply while continuing to record. Some officers will claim recording interferes with their investigation. This has no legal merit. Courts have repeatedly held that officer discomfort doesn't override constitutional rights. By the way, if you're enjoying this breakdown of your legal rights, I post content like this regularly to help you understand the law. I'd appreciate if you subscribed. Thanks. The right to refuse field sobriety tests. Field sobriety tests, the roadside physical exercises where officers ask you to walk a line or stand on one leg, are completely voluntary in every state. These tests are not scientifically validated measures of impairment, but rather subjective evaluations that provide officers with observable behaviors to justify arrest. Many people fail these tests while completely sober due to nervousness, physical conditions, age, or the inherently difficult nature of performing coordination exercises on a roadside at night. Refusing field sobriety tests cannot be used as evidence of guilt, cannot provide probable cause for arrest by itself, and cannot result in automatic license suspension. However, field sobriety tests are different from chemical tests. Chemical tests, meaning breath, blood, or urine tests, fall under implied consent laws in all 50 states. When you obtained your driver's license, you implicitly agreed to submit to chemical testing if lawfully arrested for DUI. Refusing a chemical test after arrest triggers automatic license suspension ranging from 90 days to 1 year for a first refusal. The key distinction is timing and type. Roadside preliminary breath tests are generally voluntary. The official breath test at the station after arrest is mandatory under implied consent. Refusing field sobriety tests means the officer must find other evidence of impairment to establish probable cause, such as erratic driving, smell of alcohol, slurred speech, or bloodshot eyes. The safest approach is to refuse field sobriety tests politely by saying, "I respectfully decline to perform field sobriety tests." The right to see a warrant before vehicle search. The Fourth Amendment generally requires police to obtain a warrant before searching property, but the automobile exception allows warrantless vehicle searches if police have probable cause to believe the vehicle contains evidence of a crime. This exception eliminates the warrant requirement, but not the probable cause requirement. If an officer wants to search without probable cause, they need your consent or a warrant. If they claim to have a warrant, you have the right to see it. A valid search warrant must specify your vehicle, be signed by a judge, and describe what officers are looking for. You can read and photograph the warrant. If officers arrest you during a stop, they can conduct an inventory search before your vehicle is towed. Inventory searches are administrative procedures to catalog property, but anything found can be used as evidence. If an officer searches without consent, without probable cause, and without a warrant, the search is illegal and evidence should be suppressed. Several exceptions exist. If contraband is in plain view, officers can seize it without a warrant. If you're arrested, they can search the passenger compartment within your reaching distance under Arizona v. Gantt. If they believe the vehicle contains evidence that could be immediately destroyed, exigent circumstances may justify warrantless search. Refusing consent is critical because consent eliminates all legal questions and makes any search automatically legal. Without consent, the state must prove the search fell within an exception. The right to ask if you're free to leave. A traffic stop is a seizure under the Fourth Amendment, meaning you're not free to leave without permission, but this seizure is only justified for as long as necessary to complete the stop's original purpose. Once the officer has checked your documents and issued a citation or warning, the stop should end. Many officers extend stops by continuing to ask questions or requesting consent to search. You have the right to ask, "Am I free to leave?" or "Am I being detained?" These questions clarify your legal status and force the officer to either release you or articulate why you're still being detained. The Supreme Court ruled in Rodriguez v. United States that police cannot extend a traffic stop beyond the time reasonably required without reasonable suspicion of additional criminal activity. If you ask if you're free to leave and the officer says yes, depart immediately. If the officer says you're being detained, ask why. The officer must articulate specific facts justifying continued detention. Vague statements like, "I want to ask a few more questions," don't meet the legal standard. Courts examine how long the stop lasted and whether it exceeded the time necessary to address the violation. A stop for a broken taillight extending to 30 minutes while the officer questions you about drugs is likely unreasonable. The question, "Am I free to leave?" Signals that you understand your rights and aren't volunteering for an extended investigation. Document the time the stop began, when you received your citation, and when you were allowed to leave. The right to have passengers remain silent. The Fifth Amendment protection extends to every person in your vehicle. Passengers have the right to remain silent and cannot be compelled to answer questions. The law surrounding passenger identification varies by jurisdiction. In 24 states, stop and identify statutes require passengers to provide names if police have reasonable suspicion they're involved in criminal activity. However, reasonable suspicion must be individualized to the passenger. Being a passenger in a car pulled over for speeding does not create reasonable suspicion. In the remaining 26 states, passengers have no obligation to provide identification unless suspected of a specific crime. The Supreme Court ruled in Maryland v. Wilson that officers can order passengers out of the vehicle during traffic stops for officer safety reasons, even without suspicion. Once outside the vehicle, passengers retain Fifth Amendment rights. They can refuse to answer questions about where they're going or what's in the vehicle. If an officer asks a passenger their name, the passenger can respond, "Am I required to identify myself?" Passengers should be especially careful about admitting ownership of items in the vehicle. If an officer finds drugs and asks, "Whose are these?" every occupant should remain silent. Admitting ownership creates criminal liability. Passenger rights are frequently violated because passengers don't know they can refuse to answer questions. You're in a nearly identical legal position to the driver regarding Fifth Amendment rights. The right to refuse vehicle exit, with exceptions. You do not have a constitutional right to remain in your vehicle during a traffic stop. The Supreme Court established in Pennsylvania v. Mims that officers can order drivers out of vehicles during traffic stops without any suspicion of threat. This was extended to passengers in Maryland v. Wilson. If an officer tells you to step out, you must comply. Refusing can result in charges for obstruction. However, this authority has limits. Once you're out, officers cannot search you without reasonable suspicion that you're armed and dangerous. A pat-down for weapons requires the officer to articulate why they believed you might have a weapon. General nervousness cannot justify a Terry frisk. The frisk is limited to feeling for weapons over your clothing. Being ordered out doesn't automatically authorize a vehicle search. Officers also cannot search the vehicle unless they have probable cause or another exception applies. Some officers will order you to the back of your vehicle while another officer searches your car. If you're not under arrest and haven't consented, you can ask why the vehicle is being searched. While you must exit when ordered, this compliance doesn't waive your Fourth or Fifth Amendment rights. You can exit while still refusing consent to search and still remaining silent. The right to document and report violations. After a stop concludes, you have multiple avenues to report rights violations. Document everything while your memory is fresh. The officer's name and badge number, the time the stop began and ended, the stated reason, all questions asked, whether you consented to anything, whether you were searched, and witness contact information. If you recorded the interaction, back up the recording immediately to cloud storage. Police have been known to seize phones or delete footage. You can file a complaint with the police department's Internal Affairs Division or Civilian Oversight Boards where they exist. If the violation was severe, consult a criminal defense attorney if you were charged, or a civil rights attorney if considering a lawsuit. Criminal defense attorneys can file motions to suppress evidence obtained through illegal searches. Civil rights attorneys can file lawsuits under Title 42, United States Code, Section 1983, allowing people to sue government officials for constitutional violations. These lawsuits require proving the officer violated clearly established rights and isn't entitled to qualified immunity. You can also file complaints with state attorney general offices or the Department of Justice Civil Rights Division if targeted based on protected characteristics. The most important principle is that your rights don't end when the traffic stop ends. If an officer violated your constitutional protections, you have legal recourse, but only if you document the violation and pursue it through proper channels. If you enjoyed learning about your rights during traffic stops, consider subscribing so you don't miss out on future uploads. Thanks for watching.